zoning administrator. And it's a two-part standard, and it deals with proximity, and it deals with a particularized harm. And as you know, and hopefully you've had an opportunity to look at the packet of information that we submitted. Mr. Gupton, on behalf of GPA, submitted a very lengthy declaration, and it goes into great detail. But in terms of the proximity, Mr. Gupton has represented, and he owns a number of properties in the town of Gordonsville, over 20, I believe, but 3 of them are within 2,000 feet of the Gordonsville, of the Gordon House itself. It was the Virginia Supreme Court in the Riverview Farm case that opined that a third-party challenger who was within 2,000 feet of the particular property issue qualified for having standing or meeting the prong of proximity. And so we think that particular prong is met. In terms of the particularized hardship, the particularized harm, what you've seen and what you've read in Mr. Gupton's representation, and he's here tonight, and we appreciate the opportunity for the continuation to allow him to speak later as well. But what he represents is someone who's been in the town for 25 years, who owns a significant amount of property, who has invested millions of dollars, who has a real estate management, property management company that is ongoing, and he has relied specifically on the language, on the intent of the town ordinance. He has made financial commitments based on that language. And so if anyone has the potential of having a particularized harm associated with a use that's going to have an adverse impact on his business, it is Mr. Gupton and it is GPA. And so we would submit to you that in terms of standing, GPA most certainly meets the particular standard as laid out by the Virginia Supreme Court. There's a case that I cited in the brief. It's the Anders v. Larson case. It's a recent case from the Virginia Supreme Court. It's out of Fairfax County, and it just so happens to involve a residential treatment center. Okay, at issue was the residential treatment center's attempt to go into a residential community. And there were neighbors who challenged that. It was a BZA challenge, went on to the circuit court and went on to the Virginia Supreme Court. And in that case, the Supreme Court found that the challengers had qualified, had checked the box of the particular harm if they were able to articulate that there was diminished, potential diminishment of property values as well as traffic concerns. Well, that has certainly been alleged in the declaration that's been attached to Mr. Gupton's statement. This will most certainly have an impact on his ongoing business and his ability to rent his properties that are in the town. So, in terms of one of the things that struck me from the last hearing is there was really kind of, and it's woven throughout their brief as well, but for Cardinal Wellness, it's really 3 themes, okay, that kind of come through. And one of the themes is, BZA, pay no attention to what's going on in the rest of the world. Focus only on the town of Gordonsville, only on the ordinance itself. Pay no attention to Virginia law that's above. But I brought a particular statute that's important I believe, for your consideration. And this is one of the foremost statutes. It's right up front in the first volume of the Penal Code, section 1-248, and it's the Supremacy Clause. And the Supremacy Clause provides that the Constitution of the United States, of course, but also Virginia's Constitution and all Virginia laws are supreme. And that no local government's bylaws, rules, or regulations can be in conflict with those laws. And so contrary to what you're being urged to think about or consider in terms of only looking at the town ordinance and what is a hospital, you must look at Virginia law because Virginia law is supreme and it controls. And in this particular area, we have an entire body of law that's dedicated to the Department of Health. And the Department of Health lays out the regulations, it lays out the rules, it lays out the licensing requirements, everything that's associated with a hospital. It tells us it's specific. And what is very clear is that you have to be licensed by the Department of Health. And then there's a whole nother body of the Virginia Code that deals with the Department of Behavioral Health. And that also has a number of rules and regulations and requirements, and it's comprehensive as government continues to grow, as we all know. It's comprehensive, it's overwhelming. But nonetheless, that's the section that deals with the 3.1 ASAM clinical residential facility care, okay? And there's another provision, I'll provide you this one, and council cited this one in their brief. And this is one of the provisions of the Department of Behavioral Health. And it tells us what is the 3.1 ASAM facility. And I've highlighted it for you. I specifically highlighted it for you. It refers to the clinically managed low-intensity residential services, the ASAM level 3.1. It's the agency-based residential group home services that shall be licensed by the Department of Behavioral Health. Virginia law characterizes the particular use that they're proposing as a group home, not as a hospital. And Virginia law is very clear that a hospital has to be regulated by a whole separate governmental agency, the Department of Health. The second theme that you were encouraged to kind of think about and kind of be focused on, and I would refer to as kind of the blinders, line of thinking. And that is, pay no attention to the entire definition that's in the town ordinance. Only look at the words itself that describe the particular use. Pay no attention to the actual use. In other words, only look at how a hospital is described, or a special care hospital. Don't look to the fact that it is actually a hospital. Okay? So what they are attempting to try to have you do is that it's like as if there was a definition of a dog. And the dog is defined as an animal that can be domesticated, that has a head, a body, a tail, and 4 legs. And Cardinal Wellness comes up to you and says, look, I have a cat, and it meets the definition, therefore it's a dog. Well, you can't do that. You have to actually look that the definition is talking about a dog. And here, we're talking about a hospital. And a hospital, as we know, is defined by Virginia code. You can't simply say that something meets a particular loose, vague definition and think that it meets that definition. But one thing has been perfectly clear, gentlemen. They haven't lied to you. They haven't misrepresented. They've been brutally honest. They have said from day one that they are not a hospital. They've said it repeatedly. In the correspondence in July of 2023, there's correspondence between the representative and the zoning administrator where they call themselves, there was discussion where the zoning administrator said that they were a group home. And they said yes. And they said no, and most certainly we're not a hospital. We're not going to provide medical services. In the lease agreement that they signed in March of 2024, it specifically describes the use that's going to be proposed. It's proposing, as defined by Virginia code, the group home, not a hospital. In the business application, the new business application for the town of Gordonsville, there's a box, okay? There's a box that you can check if you are going to operate a hospital. You have to pay a separate license fee. They did not check that. On the commercial zoning application that they submitted, the initial one, they indicated that they were a special care hospital, but they retracted that. They changed it. And you know why? Because it's a felony to represent or to operate a hospital in the state of Virginia if you're not actually a hospital. So they made that correction. They cleared that problem up. Even when the community found out about this particular project and really kind of erupted, Cardinal Wellness went on a full-on PR campaign, and they had the presentation to the town council, and we've submitted to you the videotape on that. Even at that point in May of this year, they said, when asked specifically, "Are you a hospital?" They said no. So they've been honest with you. They're not a hospital. You know, the lease agreement, if you look at that, they couldn't even operate as a hospital because the lease itself has guardrails on it. It doesn't allow them to expand the use beyond the group home that they've identified there. So they couldn't even operate it if they want to. The third point is that what we call the thing decided that they want you to decide. It's kind of an authoritarian kind of thing decided. It can't be challenged, okay? And in the initial kind of salvos and these briefs that were going back and forth, you know, there was much that was made about the thing decided, and it kind of backed up. It's kind of a thunderous roar that kind of was shot into the air and didn't hit anything. And the reason is because if you take out the zoning administrator's determination from August, and there was a series of them, they went out through the fall, they went to various representatives of Cardinal Wellness. If you look at the actual language, dust it off, take a look at it, you'll see that the only thing that the zoning administrator opined about, she said that a hospital and a special care hospital, which of course we take issue with, but nonetheless, those were allowed in the zoning districts. That's all it says. The determination says nothing whatsoever in terms of what Cardinal Wellness was proposing as their use. There's no link. And so there was never a zoning administrator determination as to what Cardinal Wellness's use. What triggered this whole thing is when the zoning administrator signed off on that commercial zoning permit. And that's what triggered this. The other point that I would like to make is that, and it's the technical argument that's in the brief, is that, you know, folks, we're dealing with an application that doesn't even include all the parcels. You know, they got the names wrong, they misspelled their own name, they didn't include the properties, the addresses are wrong. I mean, the list kind of goes on and on. But the bottom line is that they're operating off of a commercial zoning permit that's been approved that doesn't actually, the application didn't actually include all the parcels that are necessary to operate the operation. And that's defective. And for that reason alone, it should be reversed. So really, you know, at the end of the day, the real question that you all have to ask is Cardinal Wellness licensed by the Department of Health? Because they have to be a hospital. And if they're not, then they are the group home use that the regulatory code section says that they are, related to the Department of Behavioral Health. And we know that the town ordinance says if the use isn't specifically permitted, it's prohibited, okay? And, you know, I had the pleasure of being involved in a case many years ago here in Orange County. It was in Barboursville. And that was a case that went to the Virginia Supreme Court. The namesake is sitting right behind me, that was involved with that case. But that was a case where it was an attempt to run a shale mining operation through a residential zone. And we said, wait a second, the zoning ordinance doesn't allow a mining operation in a residential zoning district. And we had to go all the way to the Virginia Supreme Court for the Virginia Supreme Court to say, you know what, you're right. If the zoning ordinance does not allow the use, you cannot make it fit into another use. It's prohibited. Just like you cannot fit a 3.1 ANSAM residential substance use facility. I know it's a word salad, but nonetheless, it's a group home into a hospital use, because it's not allowed. Thank you for the opportunity to speak with you. Really appreciate it.
Good evening, Mr. Chair, members of the board. My name is Lori Schweller. I'm an attorney with Williams Mullen, representing Cardinal Wellness Center, LLC. With me tonight are Christine Weber and Michael Weinstein on behalf of the applicant. You've heard a lot of information, so I would like to clarify the legal issue for you to decide tonight. There is a threshold question whether the appellants have a legal right standing to make these appeals. We strongly believe they do not, but the substantive question, whether the proposed use is permitted, is so straightforward and unambiguous that I decided to skip the standing analysis and move directly to the substantive legal question. The question is simple. Did the zoning administrator correctly determine that the proposed use is a special care hospital, which is a use permitted by right in the B1 and B2 business zoning districts? If the use is permitted by right, there is no impact analysis to be made. There should be no argument or complaint against it. There are no public hearings. The Gordonsville Town Council already decided the use was appropriate when it established the zoning for the parcels. It's like building a house in a residential zone district. It's simply allowed by law. We are not dealing with a rezoning, when the zoning district must be changed to accommodate a use. We are not discussing a conditional use permit, when the planning commission and town council must evaluate the application by certain criteria: traffic impacts, need for the proposed use, the character of the neighborhood, the effect on property values, and impact on the health, safety, and welfare of the neighborhood. Again, these are questions and criteria for conditional use permits which require public hearings. In this case, none of these queries or criteria have any bearing whatsoever on the question at issue here tonight: whether Cardinal Wellness Center may operate a special care hospital in the business districts. You are not evaluating any of those criteria because the proposed use is permitted by right anywhere in the B1 and B2 business districts. The property is already zoned for the proposed use and no conditional use permit is required. It is a by right use. Therefore, issues such as traffic, safety, property values, and the character of the neighborhood are not legally relevant to this decision. Let me reiterate, the B1 and B2 zoning districts are business districts. The proposed use is a commercial use in a commercial zoning district. The Gordon House property could become tomorrow, without any public hearings or approvals, a grocery store, a McDonald's, a service station, a car dealership, a fire and rescue station, and any number of other commercial and institutional uses listed in the zoning ordinance. Zoning ordinance controls what may be built in the business districts. Hospitals, including the category, quote, hospital, comma, special care, end quote, are uses permitted by right in the business districts. The Gordonsville zoning ordinance defines hospital as an institution rendering medical, surgical, obstetrical, or convalescent care, including any institution licensed as a hospital by the state hospital board. Note, the ordinance does not say only those that are licensed, it says including those that are licensed. Hospitals, as defined by the zoning ordinance, do not have to be licensed as hospitals by the state hospital board. The zoning ordinance definition of hospital includes licensed and non-licensed institutions rendering medical care. That is, state licensing as a hospital is expressly not required for the use to be classified as a hospital under the zoning ordinance definition of hospital. Cardinal Wellness Center will be a state accredited and regulated facility providing level 3.1 and 2.5 services. These level designations come from the American Society of Addiction Medicine. Level 3.1 facilities must provide physician consultation and emergency services arrangements for medically necessary procedures, and pharmacotherapy for psychiatric needs, medication-assisted treatment on-site or through referral, and arrangements for higher and lower levels of care and other services. Level 2.5 facilities also must provide at least 5 hours of skilled treatment services per day. The Gordonsville zoning ordinance defines the subcategory hospital, special care as an institution rendering care primarily for mental or feeble-minded patients, epileptics, alcoholics, or drug addicts. I'll repeat, the town zoning ordinance definition for special care hospital is an institution rendering care for alcoholics or drug addicts. In other words, exactly what my client is proposing. No one has disputed that. Regardless of the complaints and accusations, no appellant has even attempted to show that Cardinal Wellness Center will not be an institution rendering care for alcoholics and drug addicts. That is indisputable, and that is the description of the special care hospital use permitted by right in the B1 and B2 business district. The zoning ordinance expressly allows hospitals in the B1 and B2 business districts. Special care hospital is a subcategory of hospital. It is listed as such in the zoning ordinance. Hospital, special care, meaning it's a type or subcategory of a larger category of hospital. In zoning ordinance interpretation and analysis, that means that special care hospitals are permitted wherever hospitals are permitted generally in the town of Gordonsville. If special care hospitals are not allowed in the business districts, they are not allowed anywhere. Again, allow me to elaborate on the typical structure of zoning ordinances and their interpretation. Whereas in the business districts, the ordinance permits all hospitals generally, then that permission includes special care hospitals. Where an ordinance only permits special care hospitals, general hospitals would not be permitted. The ordinance's treatment of schools is another example of this drafting principle. The ordinance separately defines trade, commercial, public, and private schools. Where the ordinance refers to schools generally, it means all schools, whatever the subcategory. For example, fences surrounding schools cannot be more than 14 feet high. That means that the fence specification applies to all schools. By contrast, the ordinance refers to a specific type of school in other instances. For example, the ordinance only permits private schools in B1 districts. That means other types of schools are excluded from that district. The specific definitions in the ordinance allow the drafters to refer to specific types and exclude more general types. But references to the general do not exclude the specific. Instead, references to the general include the specific. Therefore, as the zoning administrator concluded, a general reference to hospital includes special care hospitals. Her determination was correct and must be upheld. The zoning administrator has authority under the Virginia Code and pursuant to section 802.02 of the town ordinance to administer and enforce the zoning ordinance and to issue zoning permits for use in conformance with the provisions of the ordinance. Even if the board would interpret the ordinance differently, the board must defer to the zoning administrator's interpretation because it is supported by the text of the ordinance and her interpretation allows for its consistent application. Appellants have the burden to rebut the presumption that this decision was correct by a preponderance of the evidence. They have presented no evidence that the proposed use will not be a special care hospital as clearly defined by the zoning ordinance. Please allow me to reiterate what this hearing is not about. It is not about state licensing. Localities control their own land use, and the only definition relevant to this decision is the town's definition of special care hospital as an institution rendering care to alcoholics and drug addicts, a definition that exactly describes my client's proposal for Cardinal Wellness Center. Second, this hearing is not about the applicant's ability to define the use. The appellants have accused the applicant and its agents of lying or attempting to hide their true plans. This is far from the truth. The applicant has gone above and beyond to introduce the project to the community and town council, which they were under no obligation to do. So far from trying to hide their plans, they filled out the zoning forms with Ms. Kendall. They added more descriptive information to the second which helped Ms. Kendall better understand what activities would actually take place in the facility. There was no attempt to mislead. The applicant's agents simply aren't zoning specialists. Joel Kahano specializes in finding suitable real estate for treatment facilities. Michael Rothstein is a healthcare provider and administrator. His statement that the proposed use is not a hospital was based on his experience with state healthcare regulations, not the zoning ordinance. It is the zoning administrator, not the applicant, who decides how the use is defined under the zoning ordinance based on the facts. Her interpretation must be upheld unless the evidence proves otherwise. Third, this hearing is not about the applicant's control over the property. The property is under lease and the property owner signed the zoning forms. The lease formerly contained a typo regarding one of the 4 tax map parcels, which the parties are correcting. The property owner itself signed a second application, so clearly site control is not an issue. The property is identified by owner and tax map parcels where the building is located. Typos in one of the addresses can easily be corrected. Fourth and most important, this hearing is not about alleged impacts on the neighborhood, such as safety, property values, traffic, tourism potential, and so on. The proposed use is a by right use in the business districts, so no impact analysis is necessary or even allowed. You may sympathize with the appellant's concerns about having a special care hospital in the neighborhood, but the zoning ordinance permits special care hospitals by right in the B1 and B2 business districts. Since the use is permitted by right in these districts, there is no call to evaluate the impact on the neighborhood. In summary, Cardinal Wellness Center has been unfairly criticized for months, accused of breaking the rules and even lying to the town. The reality is that Cardinal Wellness Center will provide a much-needed treatment facility to the community, which the zoning ordinance allows by right in the business districts. A special care hospital is an institution rendering care for those overcoming addiction to alcohol and drugs. That is exactly the use that Cardinal Wellness Center LLC is proposing. This is a permitted use under the Gordonsville zoning ordinance. Ms. Kendall's decision was clearly correct, and no evidence has been presented otherwise. We respectfully ask that you uphold the decision of your zoning administrator.